I've watched a lot of defense attorneys walk through my courtroom doors over the years, but nothing, and I mean nothing, prepared me for the morning Preston Caldwell III walked in and treated my courtroom like a hotel lobby he hadn't checked out of yet. He was representing a man named Dominic Hale, the 34-year-old son of Gerald Hale, who was at that point the managing partner of Hale, Whitmore, and Cross, one of the oldest and most connected law firms in the state. The Hale family was worth an estimated $1.7 billion, and every single person in that room knew it because Dominic Hale made sure they knew it. But I'll tell you something. What happened in the next 45 minutes became the story they still talk about in the clerk's office on slow afternoons. Because what Preston Caldwell whispered to me on his way out that door didn't just end a legal career. It changed a life. Maybe two. And I've been carrying this one for a long time. Now let me back up a second. I need to tell you about Preston Caldwell first, because you can't understand what he did without knowing who he was. Caldwell came from money. Not Hale family money, but old county money, the kind that gets you a good address and a name people recognize at charity events. He'd been a defense attorney for 19 years. Custom suits. And I mean actual custom, not the department store kind that passes for custom. Every time I saw him in a courtroom, the lapels were slightly different. The shoulders fitted in that particular way that costs real money. The morning he walked into my courtroom for this trial, he was wearing a charcoal Brioni suit, or something close to it. I don't follow menswear, but my clerk Denise, who has an eye for these things, clocked it at $4,000 the moment he cleared the doors. He carried a butter-soft leather document case, dark cognac, monogrammed PRC in gold at the clasp, and he set it down on the defense table the way people set things down when they want you to know they own the room. He arrived 22 minutes late. Not fashionably late, disrespectfully late. I was on the bench. The bailiff had already called order. The victim's family was seated and waiting. The court reporter had her fingers on the keys. And Preston Caldwell walked in, didn't address me, didn't apologize, didn't even slow his pace as he came down the center aisle. He leaned over to his associate, a young woman in a gray blazer who looked like she'd rather be anywhere else, and said something that made her pull a file from the leather case. Then he looked up at me, gave a single nod as if we were colleagues who'd agreed to meet here, and said, "Your Honor, ready to proceed." I looked at him for a long moment. Strategic silence works wonders on people who think they're in control. He held my gaze for about 4 seconds, then looked down at his papers. His client, Dominic Hale, was seated beside him. Dominic was wearing a pale blue Keaton sport coat. Yes, his clerks filed his wardrobe choices in a personal styling app, which we found out later, with a white pocket square that probably cost what some people pay for a week of groceries. He was lean, tan in the middle of February, and he had that particular kind of stillness that very wealthy young men sometimes have, the stillness of someone who has never genuinely worried about an outcome. There was a Patek Philippe watch on his left wrist. I noticed it because the courtroom lights caught the bezel when he moved his hand. He looked, in short, like a man who had been told this would all be over by lunch. Now let me tell you about Marcus Webb. Marcus was sitting at the plaintiff's table with his attorney, a sole practitioner named Cheryl Odom, who drove 40 minutes each way from her office in a strip mall off the highway. I want you to picture Marcus for a minute because it matters. He was 51 years old. He'd worked as an HVAC technician for 23 years, or was it 24? I'd have to check the file, for a commercial building services company that maintained large office complexes downtown. He came in that morning wearing a button-down shirt in a deep navy blue, the kind of shirt that had been ironed very carefully. There was a small mended seam near the left collar, stitched back with thread that was close, but not quite the same shade as the fabric. His hands, when he folded them on the table, were the hands of a man who had used them for 20-plus years, calloused at the thumb joints, a faint scar across the right index finger where something had caught him years ago, the skin around the knuckles permanently darkened in the way that industrial work does to a person's skin. He had 3 kids. The youngest was 7. Her name was Imani, and I mention her because of the thing Marcus had in his jacket pocket, which I'll get to in a minute. Marcus wasn't loud. He wasn't angry. He sat there at that table with his hands folded, and he looked straight ahead. And in all my years on this bench, and we're talking 41 years, folks, 41, I can count on one hand the number of people I've seen carry that particular kind of quiet. It's the quiet of someone who has been waiting a long time for someone to simply listen to them. The case itself was a civil matter, a workplace incident 11 months prior. Dominic Hale had been touring one of his family's commercial properties. The Hale Group owned several large office buildings downtown, in addition to the law firm, and Marcus Webb was on site performing a scheduled HVAC maintenance check on the 14th floor. What happened next was disputed. Dominic Hale's version was that Marcus had been careless with a pipe fitting and that water damage to the 14th floor was Marcus's fault, and that the Hale Group had fired Marcus and was suing him personally for $64,000 in damages. Marcus's version was that Dominic Hale had confronted him in the mechanical room, grabbed him by the forearm, shoved him into a utility shelf, and that the pipe fitting had been knocked loose in that altercation, and that Marcus's right wrist had been fractured in the fall, and that none of that was an accident. I want to tell you about the jacket pocket before I get to what happened in the courtroom. Marcus had a small folded piece of paper in the left inside pocket of that button-down shirt. I didn't know it was there until the middle of the afternoon session, but I'm going to tell you now, it was a drawing. His daughter Imani had made it that morning before school, the stick figure kind with the sun in the upper corner and a house below it, and Marcus's name in large crooked letters, M-A-R-K-S. She'd spelled it wrong, bless her heart. And at the bottom, in a 7-year-old's handwriting, the words, "You will win, Daddy." He'd folded it and put it in his pocket before he left the house at 5:30 in the morning. That piece of paper is going to matter. Remember that. Now, the trial had been going on for 2 days before the morning in question. Caldwell had been thorough, methodical, moderately effective in his cross-examinations of Marcus and his union rep. He was doing what high-end attorneys do, making the other side's witnesses seem unsure of their own memories, casting doubt on the timeline, redirecting attention to the water damage costs. He was good at it. I'll give him that. But on day 3, something changed. And it started with the phone. Dominic Hale's phone buzzed on the defense table, and he looked at it. Just looked at it. Right there in open court on the record. I've been on this bench for 41 years, and I still find that one remarkable. The idea that a person could sit in a courtroom and check their phone while the opposing attorney is making an argument. I let it go the first time. I noted it, but I let it go. The second time, I cleared my throat and looked directly at him, and Caldwell put a hand on his client's arm. The third time, Dominic Hale actually typed something. I set my pen down very carefully on the bench. The courtroom went quiet. Cheryl Odom stopped mid-sentence. "Mr. Hale," I said. He looked up, not startled, just looked up, the way you look up from your phone when someone calls your name at a party. In this courtroom, the proceedings before you are the only thing that exists. Put the phone away. He held eye contact with me for a half-second longer than was advisable, then slid the phone to the edge of the table near Caldwell's elbow. He did not put it in his pocket. He slid it away from him about 8 inches, like a man moving a glass of water he hadn't ordered. Caldwell, to his credit, picked up the phone and put it in the document case without a word. Smart man. What happened 20 minutes later, though, is where the morning turned. Cheryl Odom was presenting Marcus's medical records, the fracture diagnosis, the imaging, the surgical consult. Dominic Hale leaned back in his chair, looked at the ceiling, and audibly sighed. Long. Theatrical. The kind of sigh that says, "I cannot believe we are all still here." The gallery shifted. 2 jurors looked at him. "Mr. Hale," my voice was even. "Sit up, please." He sat up. Then he muttered something. I didn't catch every word, but I caught the last 3. Waste of time. The gallery went still. Not the nervous kind of still. The kind where people hold their breath. I looked at Caldwell. He was looking at the table. I gave it 3 seconds. Then, "Mr. Hale, did you say something for the record?" He looked at me. And here's the thing, and I've learned to recognize that look. It's the look of a person who has lived their entire life in rooms where their discomfort was immediately smoothed away by someone else, and who doesn't yet understand that this room doesn't work that way. I said, "This is a waste of everybody's time," he said. Clear as a bell. "My company's already paid the medical bills. We're here because he wants more money and his lawyer is milking it." The gallery erupted. Someone in the back row said something I couldn't make out, but I didn't need to. Caldwell put his head in his hands. Marcus Webb looked straight ahead. He didn't turn around. He didn't react. He just sat there with his hands folded on the table, and the only thing I noticed was that his left thumb pressed once against the inside of his jacket pocket, where the drawing was. I let the gallery settle. Then I called a 15-minute recess. Now, I'm going to be honest with you. The part of this story that still makes me set my glasses down on the bench, I'm saving for a few minutes from now. Because what happened during that recess is the heart of everything. If I tell you now, it doesn't land the same way. Bear with me. When we returned, I had the bailiff bring in the footage, because there was footage. And I want you to understand that the existence of this footage was not new information. It had been in discovery. Both sides had it. But Caldwell had argued in a pretrial motion I had denied that the angle was too oblique to be determinative. He'd lost that motion. The footage was coming in. The building's own security system had captured the 14th floor mechanical room on the day of the incident. There were 3 cameras in that corridor. The footage had been compiled and time-stamped, and it ran 52 seconds from the moment Dominic Hale entered the mechanical room to the moment he left. I called for it to be played. The courtroom was quiet in the way that courtrooms get quiet when everyone already knows what they're about to see and can feel the weight of it coming. The footage was grainy, the way building security footage always is. Low resolution, a slight fisheye on the edges, the timestamp burning in the lower right corner in white pixels. You could see Marcus's back first, crouched over an HVAC access panel at the far wall. Then Dominic Hale entered from the left of the frame. He was already talking, pointing. Marcus stood, turned, responded. The exchange lasted maybe 15 seconds, getting louder by the look of Hale's posture. Then Hale reached out and grabbed Marcus's right forearm. Not a touch. A grip. You could see Marcus's body jerk sideways. The utility shelf caught him across the shoulder blades, and his right hand went out and caught the pipe fitting as he fell against it. The fitting gave. Water began spraying. Hale stepped back. Marcus was on one knee, holding his wrist against his chest. And Dominic Hale, I watched this on the screen and I watched it again in the courtroom that day, turned and walked out of the frame without looking back. 52 seconds. I looked at Dominic Hale when the screen went dark. Blank. Absolutely blank. Not shame. Not recognition. Nothing. He was chewing the inside of his cheek slowly, the way you might chew gum, and his eyes were on a point somewhere past the screen. That was when I turned to him directly, from the bench, and began to ask my questions. Mr. Hale, I said, in the footage we just viewed, were you the individual who entered that mechanical room on the afternoon of March the 14th? His attorney, Caldwell, started to stand. I held up one finger, kept my eyes on Dominic. Mr. Caldwell, your client is not required to answer questions from the bench in a civil proceeding, and I am well aware of that. But he has already addressed this matter on the record with a spontaneous statement. So let's have some clarity. Mr. Hale? Dominic Hale looked at Caldwell. Caldwell gave the smallest shake of his head. On advice of counsel, Dominic said, I decline to respond. That is absolutely your right, I said. Let me ask you something else then. You testified on day 1 that you entered that room because you were concerned about a maintenance issue that had been reported. The timestamp on the footage shows you entered approximately 4 minutes after Mr. Webb began the repair. Does that timeline match your recollection? Caldwell. Objection, Your Honor. Mr. Caldwell, I am not cross-examining your client. I am clarifying testimony already on the record, and I am well within my discretion to do so in a civil matter. Sit down. He sat. Dominic Hale's jaw shifted. Then he said something I have thought about many times since. He said, look, he should have called a supervisor if he had a problem with me being there. That's protocol. I'm the owner. I can go wherever I want in my own building. I let that sit in the air for a moment. Your own building, I said. Yes? And in your own building, is it protocol to grab a contractor by the arm? I didn't. That's not what that footage shows. Mr. Hale, I've watched the footage 3 times. Would you like me to watch it a 4th? He said nothing. I'd also like to read into the record, I continued, picking up the papers Cheryl Odom had handed me before the recess. The victim impact statement submitted by Marcus Webb. I put on my reading glasses. Mr. Webb writes, my right wrist was fractured in 2 places. I was in a splint for 9 weeks and could not work for 11 weeks. My employer terminated my position citing job abandonment, though I had filed disability paperwork the same week. My wife works as a home health aide, and during those 11 weeks, we used the entirety of our emergency savings, approximately $9,000 to cover our mortgage, my daughter's asthma medication, and our car payment. I am not in this courtroom because I want money I am not owed. I am here because what happened to me was wrong, and I want it said out loud in a place where it has to be written down. I set the paper down. The courtroom was very quiet. I looked at Dominic Hale. His hands on the table had gone still. Caldwell was looking at the document case. Mr. Hale, I said quietly, is there anything you would like to say? He opened his mouth, closed it. His voice, when it came out, was smaller than I'd heard it. I wasn't trying to He stopped, his hands pressed flat against the table. I didn't mean for him to get hurt, which is almost an apology. Almost. It's not, though. And I'll get to why that distinction matters in a moment, because it's the whole point of everything that followed. Now, here is the part I told you I was saving. During the 15-minute recess, Preston Caldwell had gone out into the corridor. When he came back in, I could see from the bench that something had changed. There are shifts in a person's posture that happen when they've made a decision they didn't want to make, but know they have to. Caldwell had that posture. He walked to the defense table, leaned down, said something to Dominic Hale's ear, and Dominic went rigid. Then Caldwell straightened up, gathered the cognac leather case, and walked toward the bench. He stopped at the edge and leaned slightly forward so only I could hear him. And what he said to me, in a voice that was measured and quiet and clearly cost him something, was this: Your Honor, I've just received information from my client that he withheld from me throughout this proceeding. I cannot continue to represent him. I'll be filing a motion to withdraw before close of business today. I looked at him for a long moment. He met my eyes, and the thing I saw there was a man who had spent 19 years building something and was watching it develop a crack. I said nothing. He walked to the back of the courtroom. He did not stop at the defense table on his way out. The door swung closed behind him. The associate in the gray blazer was left sitting next to Dominic Hale with a notepad in her hands and no partner above her. Dominic Hale sat very still. His face, for the first time that day, had gone pale. Now let me be clear about what had happened. What Caldwell had discovered during that recess, and what came out fully over the following week as he submitted his withdrawal motion and the bar's ethics board got involved, was that Dominic Hale had provided Caldwell with a fabricated maintenance complaint form dated 2 weeks before the incident, which was supposed to support the claim that Hale had entered the mechanical room for legitimate reasons. The form had been created by an admin assistant at the Hale Group who was told it was a documentation update. The assistant had no idea it would be used in litigation. When she found out, when her own attorney contacted Cheryl Odom, she made a statement. That statement made the fabricated form inadmissible and turned the entire case on its head. Caldwell, when he found out the form was fabricated, did the only thing a lawyer with a conscience does. He withdrew. He reported the disclosure to the court, and then he went home and spent the rest of the week, as I understand it, in fairly serious distress about what he'd nearly been a part of. That took guts. I want to say that clearly. It took guts. Now, the sentencing. I stood, and the courtroom leaned forward. I'll tell you what I've learned after 41 years on this bench. When you stand to deliver a judgment, the room always does the same thing. It goes quiet in a way that's different from regular quiet. It goes expectant. Even the people who already know the outcome lean forward a little. In the matter of Hale Group, LLC, and Dominic Hale versus Marcus Webb, I said, I find for the defendant on all counts. The suit is dismissed with prejudice. Furthermore, given the submission of fabricated documentation in these proceedings, I am referring this matter to the district attorney's office for review of possible fraud and obstruction charges. Dominic Hale's eyes widened. On the counterclaim, I continued, I am entering judgment for Mr. Webb in the amount of $83,400. I watched the number land. That figure includes the $9,000 in savings depleted during his recovery period, $47,200 in lost wages calculated over 11 weeks at the rate he had been earning, plus benefits, $14,200 in medical costs and follow-up care not covered by the building's insurance policy, and $13,000 in what I am categorizing as economic disruption damages related to his wrongful termination. Mr. Hale, you and your attorneys will deliver a certified check to the court clerk within 15 business days. I wasn't done. Additionally, Mr. Dominic Hale, you are hereby ordered to complete 300 hours of community service. Those hours will be served at the Eastside Job Retraining Center, which is, I want everyone to note, the same facility where Mr. Webb is currently enrolled in a retraining program while his wrist continues to recover. The hours will be served in coordination with that center's director, and they will include manual work and facility maintenance. Not a check, not a donation. Hours. In person. Dominic Hale was looking at me as if I'd said something in a language he didn't recognize. You are also prohibited from entering any property where Marcus Webb is present in a professional capacity for a period of 3 years. And you will write within 30 days a written apology to Mr. Webb that will be reviewed by this court for authenticity. not a statement drafted by counsel. Something you wrote, "If the first draft reads like a legal document, I will send it back." From the gallery, there was a sound. I looked up. Gerald Hale, Dominic's father, the managing partner, the $1.7 billion man, was sitting in the third row. He was wearing a charcoal suit not entirely unlike his son's. He was 63 or 64, silver-haired, the kind of man who commanded rooms by standing still. He stood up. I braced myself, if I'm honest. He looked at his son for a long moment. His jaw worked once. And then, quietly enough that I had to lean slightly forward to hear it, he said, "You did this to yourself, Dominic," and sat back down. Dominic Hale's mother, seated 2 seats to the right of Gerald, kept her eyes on her son as the bailiff approached the defense table. She did not move to stand. She did not reach out a hand. The bailiff escorted Dominic toward the side door. His Italian leather loafers, the kind with the gold bit across the vamp, clicked against the courtroom floor in a steady rhythm. The associate in the gray blazer gathered the files with shaking hands. Marcus Webb sat still at his table. His attorney, Cheryl Odom, had her hand on his arm. He reached into his jacket pocket, took out the small folded piece of paper, and held it in both hands. He didn't open it. He just held it. I saw that. I set my glasses down on the bench. Honestly, that's the part I come back to. Now, the part that matters in the long view. Because this job has taught me, above everything else, that what happens in the courtroom is only the beginning. The rest happens after the cameras. And in this case, the footage had reached 4.7 million views online within 48 hours because someone in the gallery had posted a clip of Caldwell's exit after all of that goes quiet. Marcus Webb received his check in 14 business days, 1 day early. His wrist healed fully over the following 4 months. He completed the retraining program at Eastside and was certified in commercial refrigeration systems, which pays better than the HVAC maintenance work he'd been doing before. He was hired by a facilities management company in March of the following year at $62,000 a year, which was $14,000 more than he'd been making when this started. He bought Imani, his youngest, a new winter coat before the weather turned. He told me that in a letter he sent to the court, and I keep letters like that in a drawer in my office, not my filing cabinet. The drawer. As for Dominic Hale, he served his 300 hours at the Eastside Job Retraining Center. All of them. His father's lawyers had apparently suggested a settlement that would have reduced the hours, and Dominic had declined the offer. I don't know exactly why. What I know is that the center's director told me, 6 months after sentencing, that by month 4, Dominic Hale was showing up early. He was doing facility work, painting, moving equipment, basic maintenance, alongside people who had lost jobs, people in recovery programs, people starting over. He didn't talk much. He worked. And then he talked a little more. He submitted his written apology to the court 90 days in. It was handwritten on plain paper, not letterhead. I read it twice. I sent it to Marcus. Marcus sent me back a note that said simply, "Okay." He meant it. Preston Caldwell's license was suspended for 60 days by the state bar for the delay between learning of the fabricated document and his disclosure to the court. He could have argued the timeline more aggressively. It was genuinely borderline, but he did not argue. He accepted the suspension. He reopened his practice afterward, smaller, no associates. The last I heard, he was doing public defender work 2 days a week, voluntarily. Here's the thing about that. Nobody gives you a ceremony for choosing to tell the truth when it costs you. Nobody sends you a check. You just live with it, and either it settles into something solid or it doesn't. In my experience, it settles. What I've learned in 41 years on this bench is that the people who walk into my courtroom believing the outcome is already decided are almost always wrong. And the people who sit quietly with a drawing in their jacket pocket spelled wrong in crayon, trusting that someone in that room is still paying attention, they are almost never wrong. The $83,400 Marcus Webb received made a tangible difference. Specific, real, measurable. The retraining program alone at the Eastside Center, where Dominic Hale served his hours, graduated 61 participants the year this case closed. Of those 61, 47 returned to full-time employment within 9 months. Every one of those is a family that held together through a hard year because someone somewhere made a decision that the law was supposed to serve the person in front of them, not just the person who could afford the nicest document case. That's what justice looks like when it's working correctly. It's not always loud. It's not always fast. It doesn't always make the news, except when a 4.7 million view video clip forces everyone to watch a man in a Brioni suit walk out of a room because his conscience finally caught up with his paycheck. And a father in the third row says, "You did this to yourself." And a child's crooked crayon letters held in both hands turn out to be right.